DOJ weighs in on pending gun cases at the Supreme Court. Plus, reformers cement their control of the NRA. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome back to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski. TheReload.com, of course, is where you can head on over today to sign up for our free weekly newsletter to keep you up to date on all things happening in the world of gun politics and policy. The big stories we want to kick off with this week have to do with sort of a flurry of action around the Supreme Court by the Trump administration's Department of Justice and their counsel that they're offering to the court as to which gun cases they think it should take and which they think it shouldn't take. And then the big ones that they think it shouldn't take, evidently, have to do with the status of the federal ban on convicted felons from owning or possessing firearms.
Yeah, we got some more insight, I guess, into how the DOJ is approaching Second Amendment litigation this time around. And it's kind of interesting, right? It's pretty fascinating the way that they're going about this. As you mentioned, the first part of that deals with the felon in possession ban, or really prohibited persons, because not everyone involved here was a felon, and not everyone here was nonviolent either, even though that's the bulk of the court claims, the cases against the lifetime prohibition on firearm ownership. Most of those are about nonviolent felons. But, as we saw we actually got confirmation on this week. Mel Gibson, the actor and supporter of the president, had his rights restored as part of this first 10 people sent through this new restoration program at the DOJ. And his crime was not a felony, and it wasn't nonviolent. It was a domestic violence misdemeanor. So that throws a little bit of a wrench into how we've talked about this stuff in the past. But regardless, we got a brief from DOJ with the Supreme Court in a different, not in Mel Gibson's case, or even in one of the, Brian Range's case, one of the cases we've talked a lot about, but in another case that essentially told the Supreme Court, hey, don't take this case up, right? What was you wrote a piece on this. What was their reasoning?
Yeah, so pretty much it's been copy and paste in several instances of these cases. But yeah, most recently, they said we don't think that this issue is ripe for review, even though that there is obviously a difference of opinion, let's say, among some lower courts about where to draw the line and what types of offenses can be banned from owning guns for life.
They minimize that difference, right? They said,
according to the DOJ, this difference is shallow, quote unquote shallow. And then they say, and even if there is a difference of opinion, it's better addressed by our new rights restoration process rather than by a Supreme Court ruling. So we think you shouldn't take this case up. And they said it in this case. They said it in another case, the Edel Jackson case out of the Eighth Circuit, which is one of the ones that was GVR'd by the Supreme Court. So it's gone up and down the appellate chain a few times. And then they said a similar thing in the Brian Range case. You mentioned Range. Actually, last month, the deadline for the DOJ to file an appeal to the Supreme Court in that case just kind of passed without any comment whatsoever. Yeah. But a letter came out from John Sauer, who's the Solicitor General, basically informing the Senate that we don't plan to seek cert in this case. We're going to let the deadline pass. And then same exact reasoning that he gave in these other briefs that hey, we think our rights restoration process takes care of it, and we don't think that letting this ruling stand causes us much trouble at all.
Right. And Brian Range, for those who don't remember, is the plaintiff who lied about his income in order to get food stamps in the 1990s. He never served any time in jail. I think the crime was for about $2,000 worth of food stamps. Now in the 90s, the exchange rate, especially of late, or not exchange rate, but the inflation as of late, I guess that might be like $1 million today, but no, it was a relatively menial amount of money. But it was technically a misdemeanor in Pennsylvania, but because it was punishable by more than, I think, 2 years in prison, even though he did not get prison time, it qualifies as a felony under federal firearms statute under the Gun Control Act. Yeah. So he's been prohibited from owning guns ever since then, and would continue to be outside of his favorable ruling in the Third Circuit. Now, he will get his gun rights back personally after this decision from DOJ not to appeal his win at the lower courts. And it does remain a good precedent in the Third Circuit, right? But it forestalls the chance that Range was going to be able to make his case at the Supreme Court. And I think very likely would have gotten a favorable decision from the court. In fact, I think that case was set up very well at the Supreme Court, because the last case that they took on the Second Amendment at all was U.S. v. Rahimi, which was the domestic violence restraining order gun ban case. And if, for anyone who doesn't recall, the court ruled 8-1, in fact, that the ban was constitutional, but only because Rahimi was found to have been actually dangerous by a court in the earlier proceedings, and two, his ban, his gun ban, and it's a bit of a weird ban. It's like a ban on acquiring new guns during your restraining order period, but it's temporary, at least in theory. There was some dispute over how temporary those restraining orders are for some people, but regardless, as the law is written, it's a temporary ban, and the court emphasized both those points in its holding. So, Brian Range's situation is essentially the exact opposite of that, where he was never found to be dangerous to anyone in, lying about his income to get food stamps. And two, his prohibition on owning guns was both he can't possess any firearms and also his lifetime. So it's set up pretty well. And, he's not the only one, right? There's a bunch of other plaintiffs that fall into that category of late. They're some of the most sympathetic plaintiffs that the gun rights movement has, I think, at this point. And as I just mentioned, I think they were some of the best positioned to be heard at the Supreme Court. But that's not going to happen now, right?
Yeah, no, it sets up an interesting, assuming, of course, that the Supreme Court heeds the DOJ's request, which tends to happen, especially in cases like this when it's dealing with federal law. So assuming the Supreme Court listens and is persuaded by this reasoning that we shouldn't touch this issue, it does set up an interesting sort of paradigm where there's theoretically now this new rights restoration process that people may or may not be able to go through. We can maybe get into that a little bit about what we know so far about that process. But two, it like you said, it precludes people like Brian Range or maybe like Melinda Vincent, the 10th Circuit case with the woman who wrote one bad check when she was homeless, 15 years ago and
right. is
still prohibited for life from owning guns. Those folks from setting longer lasting precedent that apply nationwide and could maybe have a more forward-looking benefit to other similarly situated either plaintiffs or folks going through being prosecuted for the crime of nothing else but possessing a gun as someone that has an old conviction that's sympathetic. So it's a weird paradigm that we're headed towards, but that appears to be the situation that the Trump administration is comfortable with.
Yeah, there's certainly pros and cons to this approach. We just mentioned some of the cons here. But obviously, one of the pros could be that, a lot of those plaintiffs could certainly, in theory, get their rights restored through this process. Yeah, that is essentially the argument that DOJ is putting forth. Like, we got a process now. They should try to go through that process first before they, bring legal action. And perhaps if they're denied by DOJ, then they would still have, then they'd have a stronger case or at least more of an impetus for a case. After that fact, and honestly, what the restoration process does in practice is just make it harder to sue. Because even if the DOJ wasn't arguing this, it would probably be a pretty good reason for the court not to take up these cases anyway, even without the DOJ explicitly saying this. It's just another avenue that they can, have somebody explore before they actually use their time on the issue, because the court has been pretty reluctant to too many Second Amendment cases of late. I don't know. It feels that way, but they have done two major Second Amendment cases, or at least one major one and one minor one, I guess, since since Bruin, which was 2022. So it's 3 years. It's not that they've done 2 cases in 3 years. It's not, it's not a ton of cases, but it is, considering they've only done like 5 Second Amendment cases in the history of the Supreme Court. It's actually a fairly good pace, I suppose. But they have denied a whole lot of other cases that seem ripe for them to weigh in on, and we're going to talk about some other ones that they've kind of held over almost indefinitely at this point, right now. But they seem to be inclined to not rule on these cases unless they absolutely have to, and there's no other avenue to exhaust, because they've, like Range, for instance, they've GVR'd that twice now, right? After their previous ruling. So the question that, though, becomes how broad this rights restoration process is going to be at DOJ, because, if DOJ just ends up restoring the rights of all these questionable cases, or if they come up with like a standard that Second Amendment advocates are happy with, as far as like some sort of automated process goes. That was something that in the early sort of scandal surrounding this process with Mel Gibson and allegedly leadership at DOJ telling the lawyer who was put in charge of the early rights restoration process that they should add Mel Gibson because he's friends with the president. There was another, point of contention between her and a DOJ leadership that was more about how the process was going to work down the line, whether it would be more automated as leadership wanted or more case by case as the lawyer wanted. So, if it is automated and it is broad, maybe that satisfies a lot of gun rights advocates' objections to how the system works currently, right? Because, for the last 30 years, it was almost impossible to get your rights restored at all. Now they're on the cusp of potentially reaching the Supreme Court and getting a favorable ruling on that question. But also, if the rights restoration process gets you to the same endpoint, I guess, maybe they'll be happy with that. But that's what remains to be seen. We have no information outside of that New York Times report and what this former pardon lawyer who was fired by the administration claims, happened during this first 10 people, the process for them to get their rights back. And if it goes in that, if it proceeds along the way it has this first 10, it's probably not going to restore a lot of people's rights, especially since one of the 10, was connected to the president and was a celebrity. That doesn't bode well for your average nonviolent felon or somebody, who wants their gun rights back. So it all comes down to that. And then, as you mentioned earlier, the other con to this approach, the pro is, you could get a lot more people their rights back quickly if they do it, if that's how the administration chooses to proceed. But another one of the cons is, even if they do that, let's say the best case scenario for gun rights activists is they set up like an automated system, and just anybody has maybe their convictions nonviolent or and they've served their time and it's been X number of years and they haven't recommitted a crime, something some sort of standard along those lines. And that all goes well, and it's not hamstrung by the lack of a budget to do this stuff, because that's how it was eliminated last time, right? Congress explicitly refused to allocate money for the rights restoration process at the ATF, and so now DOJ is doing it, I guess, just out of their general budget. It's not clear how they're going to pay for this process to occur. I mean, that's another thing with this first 10 people, is they gave it to a pardon attorney, not to any sort of specialized unit for this process. And I don't know where they are going to get the funding for that unless Congress to change their mind. Maybe they will. We'll have to see. But that's another potential limitation. But even if it all goes well, the bigger problem you face is, unlike a Supreme Court ruling, which is fairly permanent. Obviously the court changes over time, and over years it can change its position on different questions. But each court ruling is fairly has quite a lot of longevity in most cases. This process could just be reversed by the next administration, even if it is as successful as a lot of gun rights activists might want it to be. So that's kind of the pros and cons list. You had a really good piece on it that dove even deeper into that discussion. But it's interesting to see them go this direction on this question. But it wasn't the only question that they dove into this week, right? With as far as Second Amendment litigation goes, right?
Yep, that's exactly right. Yeah. So it's not just that they're telling the Supreme Court to not take certain Second Amendment cases. They also have now officially weighed in to try to encourage the court to take a Second Amendment case. And it's interesting because it is a case that doesn't involve federal law, and it's not one that the DOJ itself is a party to. Yeah. And this is the Walford versus Lopez case out of Hawaii, dealing with Hawaii's so-called Bruin response law, and particularly the provision of that Bruin response law that gun rights advocates have taken to calling the vampire rule, the one that flips the default presumption when you can enter publicly accessible private property like a business or a store or something like that. Hawaii is one of those states that changed it, that you are presumably prohibited from carrying, even if you have a permit, your firearm into a store unless the owner of that store puts a sign up and gives you affirmative permission that you can carry there. And so the DOJ weighed in and said that the Supreme Court ought to take this case up.
Yeah, really unusual move, too. They don't normally do this. The DOJ will weigh in with amicus briefs after the court has granted cert in a lot of cases, even if they're not directly involved. We saw that even with the NRA case, right, last year. With Biden's DOJ was weighed in on the side of the NRA early. I think they weighed in neutrally, but coming down mostly on the side of the NRA in that First Amendment case. Wasn't a Second Amendment case. But you'll see the DOJ do this in some cases, usually because they have some sort of strategic litigating interest. Like in the NRA case, they had other cases that they were a party to, that because that case was between NRA and New York State, but DOJ had its own cases that it was defending on First Amendment grounds, and so I think they kind of wanted to influence the court into their view of what the First Amendment does and doesn't protect, right? And then just some social media cases that they were dealing with, and so. It's sort of, you can usually see why DOJ wants to get involved. This one is more interesting than that, I think, just because one, they're not a party to it, and it hasn't been granted cert. They're arguing that the court should take it up. And two, there's no clear litigating, strategic litigating purpose to it. It's more just, their statement of why they have an interest in the case is just essentially that they have an interest in defending the Second Amendment, getting the court to clarify what it means. And so it's kind of fascinating. I mean, it repeats a lot of the arguments that you hear from the gun rights plaintiffs in this case. It's a pretty well argued and written brief, I think. But, mirroring a lot of what you've seen from gun rights advocates in these kinds of gun-free zone, sensitive places cases. And it does deal with what I think is probably the most vulnerable part of these Bruin response laws, right? That so-called vampire rule, the default swap, whatever you want to call it. This idea that even if you have a license, you can't carry on publicly accessible private property like stores basically, first of all, is carrying most places, which is a point that DOJ makes in their brief. Another somewhat interesting aspect is that they encourage the court to. By the way, the lawyer in this case is Alan Beck, the gun rights lawyer we've had on the show a number of times. He was just on not that long ago talking about another one of his cases out of Hawaii, because Hawaii often has the strictest gun laws in the country. In fact, in this case, DOJ cites the idea that before Bruin, Hawaii would sometimes go for years without issuing any gun carry permits at all. Making it, I think, by far the strictest law at the time in the country. But anyway, there were two questions that the plaintiffs want the court to answer in Wolford. One is the one that the DOJ joined onto, which is this idea about the vampire rule, the default swap, whatever you want to call it. And the other one, though, was about the right years to look at for historical precedent, historical tradition, whether it's only around the founding era or whether the era around the 14th Amendment should also be taken into consideration or given equal weight, because the Supreme Court used the 14th Amendment to incorporate the Second Amendment rights and protections to the states. And so the 14th Amendment wasn't ratified until the Civil War, right? The mid 19th century. So that's been an open question and something that even the justices themselves, I think Barrett is one that's pointed out they need to answer that question. But DOJ did not, basically just said, just focus on this first question about the vampire rule. For now, that's what we think you should do. So I don't know. It'd be interesting to see if it has any impact, right? Because DOJ has the previous DOJ, the Biden DOJ, asked the court to take up a bunch of Second Amendment cases using kind of a similar logic. Obviously, different. They were on a different side of the issue, I would say, generally speaking, in that they wanted the court to uphold a bunch of gun restrictions, but they had a pretty similar logic in terms of, basically arguing the court needs to take more Second Amendment cases. The court's only done, as I mentioned earlier, 5 Second Amendment cases. I think DOJ in this brief, doesn't even necessarily consider 2016 Satano, which is a per curiam 2-page ruling about stun guns, as like a part of that catalog. So, one of the main reasons it says the court should take up this case is that it needs to explain what is and isn't protected by the Second Amendment. And there's a lot of open questions. And that was exactly the point that the previous Solicitor General made when she asked the court to take up a bunch of Second Amendment cases too. And how did that go?
Yeah, Supreme Court said, nope, thanks for trying. Play again some other time.
We're gonna wash these cases through the lower courts again, and then maybe someday we'll take them. Yeah. So I don't know if usually the court takes the Solicitor General's view of things pretty seriously, right? And but I don't know if this is a case they're not a party to. Their interest here is mainly just in getting the court to articulate more on the Second Amendment and what it does, but
it's also an interlocutory appeal, which has been one of their favorite things to deny Second Amendment petitions on. So we'll see if the DOJ's weight, outweighs that, but we'll see.
I mean, if you're Alan Beck, I think you're probably pretty happy to get this kind of backup in your case from the federal government being like, yeah, take this guy's case. It's certainly a positive for him and the other and the actual plaintiffs in the case. But it'll be interesting to see what they do, whether this is something that tips the scales in the favor of them taking up this case, because as I think we'll talk about it in the a bit later in the link section, they still haven't taken up any other of these Second Amendment cases, and some of them are still waiting in limbo. But I don't know. Interesting to see how DOJ is approaching this now. We're getting a little more concrete actions to go off of here, so we've got a better vision into it this week.
And of course, we'll stay on top of what ends up happening with the Supreme Court, whether they decide to take the Wolford case, what they end up doing with these felon cases that the DOJ doesn't want them to take. So stay tuned at the Reload for those.
And it is another one where they're well positioned to take a case like this, right? Because this is, these are Broom response laws. These are literal laws that were passed in response to the Supreme Court's ruling. And I would be surprised if there was a majority on the court that thought these don't violate the spirit and text of Bruin. So, this, especially the default swap stuff, because it makes it practically impossible to carry a gun legally, even if you get one of the permits, which I would say goes pretty well against the whole point of Bruin, right?
Yeah, just about nullifies Bruin's core holding.
Yeah.
So we'll see if they're going to stand by.
If anything, it's a bit weird that they haven't done anything about these yet. Now, and there is a circuit split too. That's another point.
Yep.
The Second Circuit in New York found, at least on the default swap part of the Bruin response law in New York, that was unconstitutional. So you have a difference between two courts, two circuits now. So even more reason for them to potentially take it up. But that hasn't borne fruit yet in this or other cases.
Certainly. But outside of the Supreme Court, we have some reporting from you this week. Your final thoughts and final recap of your time at the NRA annual meeting, including some financial updates, as well as some takeaways from the efforts of the NRA reformers and some of the successes they had at that meeting. Yeah.
So we, I was down in Atlanta covering the meeting, and I came back with, a bunch of the NRA's financial reports and compliance reports and their annual report and, all the stuff that gives you some concrete insight into what's going on there. And, the key takeaways, I think, are, there's a lot of financial takeaways, and we'll get much more in depth on that in this week's interview podcast. We're going to have Ohio State University professor Brian Mittendorf on, who has been, he's a nonprofit. He studies nonprofits, and he's been following the NRA for years and years. And so he has a lot of really good insight into, what's going on with the organization. And, one of the things, I think the key takeaway from him reading these latest reports is that the NRA is, one, it's still declining. It's still shrinking, or at least it was in 2024. But that rate of decline is slowing, right? It's shrinking. Membership dues are down again in 2024 compared to 2023, which is pretty bad because 2024 was an election year, it's a presidential election year, right? And you're still seeing a decline. Usually, NRA fundraising will fluctuate around big political events, right? That's what happens with most political nonprofits. Now, these, just to be clear, like the finances we're dealing with here are consolidated. So it's actually, like many large political groups, the NRA is actually 7 different legal entities, spanning from the probably the best known, which is the 501c4 membership organization. That's where if you join the NRA, your money, your dues go to that entity. And, they have different entities because these different tax statuses determine what you can and can't do with money, right? There's a lot of laws around that, obviously. They have like 3 political entities, the Political Victory Fund, the Victory Fund, the Special Contributions Fund, and and then they have a number of non-political entities as well. The foundation, there's like the Whitaker Center has a foundation that oversees. Whitaker Center is a big shooting range that they operate, there's 3 or so of those entities as well, and all of their finances get smushed together for these reports. So it's you get a little bit of obfuscation of exactly what's going on with each one of them at any given time. At least from this stuff, there's other reports that come out later, like the 990 federal filing that the 501c4 has to do every year. And so, you can get some more specific insight from that. But regardless, what we take away from the numbers is that the NRA is still shrinking, but it's not shrinking as fast. And there are good reasons to think that it may have reached a turning point, perhaps, and especially in the non-financial side of the organization. The reformers, as you mentioned, they performed really well at this most recent board election and this most recent annual meeting and board meeting. Reformers now control all of the major leadership positions. There was a race between the now former president, Bob Barr. Is it Bob Barr or Bill?
Bob Barr.
Bob Barr. I always sometimes I say Bill Barr, who's the attorney general. Bob Barr, the former congressman, who was president of the NRA, lost to Bill Bockenberg, who was one of the he was the first vice president. The way it's supposed to work, by the way, I don't know how deep everyone wants me to get into the minutia of the NRA's bureaucratic operations here, but just to give you an understanding, the NRA has a set of officers, right? You have the board, and then you have a set of officers that actually run the organization, right? And the most important one is executive vice president. That's what Wayne LaPierre was for decades before the corruption scandal, before he was found liable for diverting millions of funds, the NRA's money towards, private, personal, lavish expenses. And that is controlled still by a reformer candidate, Doug Hamlin, who remains in that role today. He was put in there last year, but last year you didn't have a full slate of reformers win all of those officer elections. You had some of them win, but then you have the president, then you have the first vice president, and you have the second vice president, and it's supposed to create a chain of succession. So the president serves for a year, then the first vice president becomes president, then the second vice president becomes first vice president. They pick a new second vice president, right? That is how it has been for a long time at the NRA. But during this scandal and the infighting that's gone on, that did not happen. That did not always happen. There was a guy named Willis Lee who is in the reformer camp, as of late, and he was in line to become president a couple, 2 years ago, I think it was. But instead of doing that, as they normally would, they kept on Charles Cotton, who was a LaPierre defender. That's sort of the other faction here. You have the reformers and the longtime LaPierre defenders. And when we say reformers, look, that's just referring to internal operations, transparency, conflict of interest, financial reformers. These people don't necessarily want anything different politically than the other group, right, on the board. I don't think there's been any major shift in the way the NRA approaches gun policy. I don't even think there's been any shift in the way in their sort of who they're targeting for membership, like who they're trying to appeal to. Bill Bockenberg, for instance, the guy who won the presidency here, was an alternate elector in the 2020 election in Pennsylvania. He had paid for an investigation into the election, alleging, falsely that there was that the election was stolen. And has remained a major booster of President Trump. America's First Freedom, one of their magazines, just had an exclusive interview with Tucker Carlson, who I think is, in the Alex Jones level of commentary these days. And he was on the cover. So they're not really trying to, I don't think the NRA is changing who they're appealing to or their political views by any means. So reformer doesn't mean a change in how the organization operates politically or who it's attempting to appeal to. Just, I think that's fair to say at this point. And of course, they celebrated President Trump's, even though he didn't go to the meeting this year, he did send a video message, which got a lot of praise from the reformer group and the LaPierre defenders on the board. So just to be clear on that, they're not, the reform side is not like we're going to take the NRA in a different political direction. It's just about the financial direction of the organization. But anyway, so they have this succession plan where if second moves to first moves to president, and president, goes back into being a regular board member. They had done that for years and years, decades, I think. And they stopped trying. Once there was this dispute, this internal fight, that whole succession plan got interrupted to keep Charles Cotton as president. And then now they try to do that again this year with Bob Barr, and it didn't work. They didn't want Bob Barr and his allies, a lot of the longtime LaPierre defenders, didn't want Bakenberg to become president. President's a fairly powerful position in the NRA. They get to appoint the committee members for all the different committees, the audit committee and the nominating committee and all this stuff. And but the reformers won that vote. It was fairly close, 38-34. So, and then Rocky Marshall, who's been on the show a number of times, is one of the first kind of vocal reformer board members. He was made second vice president. So he's in line to become president in 2 years, in theory, at least. And so now the reformers control really all of the levers of power in the NRA. They also remade those committees that I mentioned that the president gets to appoint. So, for instance, on the audit committee, Rocky Marshall is on the audit committee now. So is John Richardson, who, by the way, in the members' meetings, I feel like this stuff can get really confusing because you have the annual meeting, which is just the whole event, right? The exhibit floor, the leadership forum where the politicians speak, which they canceled that this year because Trump didn't come, but most years they have that. Then you have the sort of NRA administrative stuff, which includes the board meeting, which happens after the rest of the function is over. But you also have what's called the members meeting. And that's where NRA members can go and they can offer up their own resolutions. At least this is how it's supposed to work in theory. It hasn't really worked this way much over the last, probably for quite a while. It's kind of atrophied into like being a little show where the officers give a speech and there's supposed to be these reports to the members, and then nothing of any substance really happens after that until this year, where the members meeting, which again is supposed to be a way for members to offer up resolutions for the board to consider, bylaw changes or whatever they want them to do. And this year, while it was, I think there were only a couple hundred people who actually voted in any of these questions. The reformers did manage to get a resolution through for the first time that I've ever seen. And it was written by John Richardson, who's now a board member and one of the reformer group. And it was a resolution to have the NRA create a website for members that would include like all of the financial filings that are, their public financial filings, would have minutes of the board meetings on there. And then also hopefully, they asked to try and figure out a way to live stream the board meetings to members. So it's pretty interesting that got through. That's a sign of success for the reformers as well. And then the guy who wrote that resolution, John Richardson, also ended up on the audit committee with Rocky Marshall. So, and then as well, the nominating committee, which we've talked a lot about in the past, this is the committee of the board of the NRA that more or less gets to decide who can be on the ballot to run for the board of the NRA, which has been the center of a lot of corruption allegations over the years. That process was manipulated by LaPierre and his allies over the years to keep critics off the board. The only other way to get on the board is through petition, which is a much harder process. But you had actually Cam Edwards is now on the nominating committee of the NRA. He's not a board member, but he's a member of this committee. Obviously, we've had him on the show a lot of times in the past. He's the editor at Bearing Arms. He's been critical of the corruption that's gone on at the NRA. And so now he's on the nominating committee and will be one of the people who decides who gets to be on the ballot for board elections. So, all in all, I would say the reformers really cemented their control. It wasn't necessarily, some of these votes were not necessarily, the blowouts, right? It's still a somewhat divided board there, even though the reformers did much better than the other side of the aisle in the elections. It didn't translate to huge majorities in the actual board meeting in the votes they took, but it did translate to wins, right? 38-34 for president is close, but it is still the reformers who came out on top of that. So I don't know, a lot going on at the NRA. I talked to a number of members as well on the floor, and as you might expect, the exhibits, that's what draws most people, because the NRA annual meeting, for anyone who's never been, it's similar to SHOT Show, which is the annual trade show that the industry puts on in Vegas. But SHOT Show is not open to the public, whereas the NRA is. And so you have a giant floor of just all of the latest guns and accessories and ammo and all that stuff that people can go and look at. And there's giveaways and there's, fun little things that you can do. And you can buy some stuff. You can't buy guns, I don't believe, from the floor. It's not like a gun show in that sense, but you can see all the latest guns that are coming out. And so that, I think, is the biggest draw from people. But I did hear from a number of people who either are or were NRA members and were upset about the corruption issues and wanted them to, clearly move on from that era and show that they are using money properly. Not everybody felt that way. Not everybody was, a lot of people, I think, don't follow the NRA that closely, right? Even if they're NRA members, they like the mission, they like the organization. There were several people I talked to like that who just agree with the NRA's political mission. Most of them, I was kind of actually surprised because most of them, when I asked them like what they want from the NRA, they did focus more on the political advocacy side of things. Whereas in past shows that I've been to, like the outdoor show in Pennsylvania, was a lot more focused on like the training side of what the NRA does and some of the other non-political things that they wanted to see more of that. So at the annual meeting, at least this year, the dozen or so people I spoke with, they were more often than not, if they had something to say about what the NRA should do, because not everybody had like a strong opinion on the NRA either. They just some of the people just wanted to be there to see the show, the stuff that was going on. But if they did, it was mostly focused on the political advocacy. So I don't know, interesting experience. I think bottom line, again, the NRA's finances are still declining, but they're not doing as bad as they were. And there may be an opportunity for them to start pulling out of that, especially with a potential serious decline in their legal spending, which has made up a huge chunk of their expenses over the last 6-7 years. We'll get into more of that with Brian Mittendorf, but better financially positioned than they were, even if they're still on the downward slope. And the reformers, who most of their promises are explicitly about, stopping that financial bleeding, installing more transparency efforts and conflict of interest avoidance policies, and then regaining trust of members. That's like their whole mission. They now, I would say, have total control of all of the important levers of power in the NRA.
Yep. Definitely a big sign for folks looking to see some more wins from the reformers. And so listeners should definitely go check out that podcast, available for members on Sunday and for everyone else on Monday. So getting into some of the newsletter links, and speaking of Cam Edwards, as you mentioned, he had a piece over at Bearing Arms about sort of related to the topic we talked about at the top of the show, that Supreme Court has again relisted the Maryland assault weapon ban case and the Rhode Island magazine case that everyone's been closely watching. So 12th or 13th time, I can't exactly remember now at this point. It's been so long.
I don't know. Yeah. Hard to say.
So they continue to kick that can down. And they also rejected a California gun show case. So not exactly a Second Amendment case, but California's restrictions on where gun shows can be held in the state are quite onerous. And some gun rights advocates tried to get the court interested in that, and they said, no, thank you. Yeah.
So, goes to what we were talking about earlier with, will the DOJ, I think it's a really good chance that they'll listen to the DOJ on not taking like a nonviolent felon case, because now they have a pretty good excuse not to, beyond just the DOJ saying it, there is an actual process in theory that people could go through, even if we don't know the details of that process yet. But it seems like a pretty good excuse for them not to weigh in yet until that's all figured out. And this court, as you know, we've talked about on past shows, even beyond guns, like they just don't take up a lot of cases generally. And right now there's a whole lot of big constitutional questions coming out of the Trump administration's other efforts. So maybe I don't know if they want to make room for that stuff, but yeah, it sure seems like they'll take any excuse to not weigh in on some of these cases. And then, yeah, it'll be interesting to see if the DOJ asking them to weigh in makes a difference or not in the other case. Right. So, but yeah, for now I think the biggest, what everybody on either side of the aisle is probably most interested in is that assault weapons ban case and the magazine ban case. That's certainly on the gun rights side. That, you know, these other things are important, but I would say your average, gun rights enthusiast cares way more about the assault weapons ban and the legality of that than they do about, nonviolent felons. Just to be honest, like not saying they should, but that's, I think, how it plays out. These are the most watched cases, and the court's just kind of holding on to them, not really sure what's going on there.
I was going to say, well, I'll have to continue to wait and see. But on a related note, the same topic, we have a bunch of Senate Democrats that are, firmly in the majority, and the base is looking for them to do something and fight. And we at least have one instance of them trying to do that, and that's on guns, apparently. So we have Senator Adam Schiff, as well as Senator Chris Murphy from Connecticut, folks that are pretty consistent on this theme, I would say, have decided now is the opportune time to reintroduce a federal assault weapon ban bill, which... let's be real here. It's DOA in the current Congress. Sure. It was probably DOA without majorities, but
it was DOA back when the House passed it under Biden,
right? And they Senate had control of both chambers. Yeah.
Like it just doesn't have the votes. There's no Republicans who are going to support it, and
right.
They don't even have a majority of certainly have a majority of the Democrats, a vast majority of Democratic senators. I think you said it was 39, so that's 41 overall. 41, yeah, of the 45. But they don't even have their full caucus on board with this. So it's pretty much symbolic. In fact, maybe we should just give over some of the names of who weren't involved, because that's perhaps the more interesting side. Schiff and Murphy introducing a Sullivan's ban. That's what everybody expects. Although it does, perhaps signal a little bit that the election didn't really change the calculus for most Democrats on gun policy. But we did have 4, I think it is, that didn't sign on to this. So that's Fetterman, right, is one of them, which is kind of interesting.
Didn't see Fetterman from Pennsylvania, no Ossoff in Georgia. So obviously think your typical purple state Democrats that are going to be potentially vulnerable should they decide to sign their name onto a ban of the most, at least popular semi-automatic.
Although Warnock is on the list.
Raphael Warnock, that's true. He is a Georgia Democrat, and he has decided to attach his name. Maggie Hassan in New Hampshire, where gun politics tends to be a little thornier. Nevertheless, she has signed her name onto the bill. So it's interesting to see the risks and the calculation being done on a bill that's purely symbolic, because, like you said, it's DOA, and what it says about the party and their triangulation, or I guess in this case, lack thereof, on certain issues in light of the last election, which I know something you've been writing about.
Right, which brings us to, I think, our last link, which is a piece that I wrote for the Dispatch on a topic that we've discussed before, focused more on your home state there and your governor, Paulus, who is in the moderate lane of the Democratic Party, I would think, and a potential front runner candidate for the 2028 nomination, or at least, one of the top people who's, I think, out there as far as potential candidates go. He signed on to, it's not an assault weapons ban. It is a permit to purchase scheme, which is softer than an outright ban, but not by a whole lot, especially because the permit scheme is very onerous. It's similar to some of these broom response gun carry regimes, where you need a very it was like 12 hours of training, and then a high level of fees and wait times. In fact, there's no cap on the fees or wait times in Colorado, right? So, just a very onerous comparatively to, others say like Virginia's concealed carry license or Pennsylvania's concealed carry license. You don't need any training at all for that one. You just pay a fee and a background check and your picture taken, and you get your license. And there's time limits to it, And a lot of permits purchase laws also don't have super onerous requirements. There's licensing, but it's usually fairly limited and for just the ability to buy the gun. It's carrying where you tend to get more restrictions on things, requiring safety courses and things of that nature. So anyway, he signed on to that bill, which is a sign again that I don't think Democrats have repositioned themselves at all on guns in the wake of the 2024 election. You also obviously had David Hogg elected to the DNC to be a vice chair, although I don't know how long he's going to last, but not because of his gun views, right? He's getting backlash because he wants to use the party's money to primary members of the party, which does tend to raise a lot of questions from other people in leadership positions. So I think he might be out, but it wouldn't be necessarily because he has an extremely aggressive record on gun policy. Although that's what elevated him to prominence in the first place, for having survived the Parkland shooting. But and then you can also look at a number of program bills that are out there, and the Democratic support for them is almost non-existent. I think the Hearing Protection Act has one Democratic co-sponsor in the House, and I think National Reciprocity has one Democratic co-sponsor in the House. So, none in the Senate. And then you have this Democratic bill, which has almost not the entire Democratic caucus, but almost the entire Democratic caucus on board, which gives you, I think, a pretty good breakdown of where the parties are at, and sure doesn't look very different from where they were in 2023, right?
Yeah, certainly. I think that is the primary takeaway, because like we said, politically it's DOA, but the juicier part politically is what it says about how the party views its need or non-need to moderate on certain issues. So
yeah. So check out that piece at the Dispatch if you have some time. But that's, I think, all we've got for you guys this week. If you want to be the first to listen to that interview podcast with Brian Mittendorf about the details of the NRA's finances, you should head over to reload.com and sign up for a membership today, because that is how you will get early access to the show when it comes out on Sunday with the exclusive members newsletter that you get every Sunday as a Reload member. And of course, the money that you pay in dues will go to support the reporting that we do. It is the only thing that supports our reporting here at the Reload. We are an independent publication. I own this publication 100% myself. There is no secret corporate backing, and we don't have any deals with anyone to influence our reporting, and that is why we need dues to make this happen. That way we are responsible to our members and our readers rather than our advertisers or corporate sponsors or whatever. So head over to thereload.com today if you want to support the work that we do and help us keep doing it. But that's all we've got for you guys this week. We will see you again real soon.